Okay, thank you. Hi, all. Thank you so much for having me. My name is Ashley Harrington, she, her pronouns. I'm the managing attorney at the Rocky Mountain Immigrant Advocacy Network Children's Program. It's great to be here. I will go ahead and see if I can figure out how to share my screen and get started. The slideshow here, please, from the beginning. Okay. Elena, give me a thumbs up there. Can you see? Okay, great. Okay, yes, what I'm here to talk to you about today is potentially being able to change your state laws to benefit immigrant youth. Some really big caveats I want to give. First, I just want to say sorry to anybody that was at the Acacia URM-LTFC conference. This is very repetitive, basically the same information that I covered at that conference. So feel free to check out a bit if this is repetitive for you. I will go into a little bit more detail than I did at the conference, but pretty repetitive. And a major caveat I want to give is that, I am not a policy expert. My title is managing attorney. I am not, director of policy or legislation or advocacy or anything like that. And I'm certainly not an expert in these areas. I'm sure that there are some of you on this call who have far more expertise in this than I do. Maybe you have policy or something like that in your title. Some of you are far better experts in this area. If it's not you, maybe you have individuals at your organization, at your legal service provider that are experts in this area that could teach this much better than I can. But I think hopefully part of the value of me talking about it is because I'm not an expert in it. I'm not a policy person. I'm just a kids immigration attorney who basically identified some problems that my clients were having and tried to figure out if there was a way to fix it on the state level. So hopefully some of you, right, who are also immigration attorneys or working directly with youth as direct legal service providers, just to know you don't necessarily have to be a policy expert or have that in your title or anything like that in order to identify issues that your clients are facing that you might be able to help fix on the state level. I also really want to give a caveat that I recognize that I feel really lucky to be in Colorado for many reasons. It's really beautiful here, and we have 360 days of sunshine if anyone ever wants to move here. But on this topic, I feel very lucky to be in Colorado because we have some legislators that are really passionate about immigrant justice and passing legislation to help our immigrant communities. And it is a very blue legislature at this point in time, and so it was possible to pass this legislation. And I just want to recognize that for folks that are in states that might not be as immigrant friendly or might be Republican controlled, it might be much more difficult to pass legislation in your states. But I would say, some of the partners that we've had on some of these bills that I'll talk about here, we didn't just partner with sort of immigrant justice organizations or other legal service providers. We partnered a lot with child welfare agencies, with folks that care about foster youth, for example, with crime victim agencies and advocates. So there are lots of other partners, maybe even in a state where it would be difficult to pass, pass legislation that is, intended to benefit immigrant communities through partnership with different kinds of organizations that still might be possible. I also want to note that the bills that we've been able to pass in Colorado haven't carried a fiscal note. We've been able to avoid basically being tagged with that our legislation was going to create a cost in our state budget or create a cost for our courts. And I recognize that a lot of states serve a lot more youth, a lot more individuals than we do, right? And so inevitably, these changes in legislation would impact more people and therefore probably carry a fiscal note and carry a cost, and that can be much more challenging in some states to get through legislation when you're asking for money from the state budget, in particular for folks without status. And then just noting that, I'm really going to highlight two bills for you all today, and then just sort of list a few others, and just know that like everyone has been different, every process has been different, the stakeholders and partners that we've had have been different for every single one, and we are 5 years in now to working in the state legislature in Colorado, and we are still absolutely learning. Each bill teaches us a different way to do things, and still very much learning. So those are my caveats. I do have this fun little guy here. Any of you who are old enough to know this character, honestly, like I said, right, I'm not an expert in policy, not an expert in legislation. I truly in 2019 or 2018, I guess, as we got started on our first bill, had to watch the video, the Schoolhouse Rock video, how does a bill become a law? And I had to go for a walk with a friend of mine that is in policy and ask her, like, how does a bill become a law? How do you even start this process? Who gets to do this process? It was all like, you know, the Oz behind the curtain. I had no idea. So anyway, I find that cartoon to be very spot on and accurate, but that's where I started 5 years ago, was literally trying to figure out, you know, how does a bill become a law, and have been super, super grateful to get to be part of the process now on, I think 6 bills in Colorado. So the first problem that we identified that could potentially have a state solution was that our youth were aging out of our state court at 18. And also that some of our state court judges were very hesitant to make special immigrant juvenile status findings for youth, right? That they thought, oh, you're asking me to make an immigration decision, or I don't have authority to do this under the state law. So really focusing in though on the age out issue, that kids were only able to get into state court, and I know it's different in every state what kind of court you're going into. For us, it was custody and guardianship proceedings that we were trying to go into in order to get SIJS predicate orders. And I always say that like half of my gray hair was caused by my own children, and half of my gray hair was caused by how many kids were coming to us at 17 and a half, 17 and 9 months, 17 and 11 months, who were SIJS eligible, but we were like, oh, are we going to possibly be able to get you through this process before you turn 18? Or even more tragic, right? The ones that would come to us that had already turned 18, and we said, I'm so sorry, you would be eligible for this pathway under federal law, but unfortunately, under Colorado law, you're locked out at 18. So if we could launch our first poll, please. I would love to know from folks here if you have this same problem, again, focusing on the age out piece of the problem. Are kids aging out in your state at 18? So first answer is yes, kids age out at 18. Second answer is nope, we've already fixed this in our state, or our state law is already good to go. State courts have jurisdiction up to 21. The other answer maybe is it depends, right? Maybe in certain proceedings they age out at 18, and other proceedings you're good to go until 21. And others might say, I don't know. I don't know who all the wonderful folks are who are here today. Some folks might be saying, I don't know. I don't even know what you're talking about. I don't know what SIJS findings are, right? Or what kind of state court proceedings you're talking about, or just I don't operate in this practice area. I'm not sure what my state laws are in terms of when people age out at 18 or maybe up to 20. Let's see, we have 53% participation. I don't know. That's pretty good, right? More than 50%. Maybe we'll give it one more second for me to take a sip of my coffee before we close it. Okay. Really great to know. It looks like over 50% of folks that responded have this issue in your state, right, where kids can only get into state court at 18. About 20% of you already have great state laws that you or your colleagues have fixed to give jurisdiction up to 21. About 10%, it depends. And I would say in Colorado, it kind of depends too. We have some better than others, but and then about 13%, I don't know. Okay, super helpful. Thank you so much. I think we can end that poll. So we did have this problem in Colorado. Oh, share results. Am I doing that? Are you doing that? Oh no.
I did that, sorry. I think I closed it out now.
Okay, perfect. I still see it on mine, so I will do that. Now is it gone for everyone? Okay, great, thank you. Okay, so we did have this problem in Colorado. Uh-oh, now it doesn't want to listen to me anymore. Okay, phew. Okay, so we had this problem in Colorado. Again, the first place that I started was to figure out, how does a bill even become a law? How do you change your state law, right? How do you not just accept it as, you know, set in stone, that no, in Colorado it ends at 18, so therefore we cannot do it, right? How do you start to challenge that mentality and say, well, somebody put that law on the books, right, that said that a minor is up to the age of 18, or that you could only access guardianship proceedings or custody proceedings up to 18. How do you change that, right? People are changing state laws all the time. So first, just learning a little bit about the basics of that process, right? And I'm sure it looks different in different states, but I definitely had to learn about how that works at the Colorado legislature. And then the other thing that I did was start to research other states, some of the 20% of you that answered, right, that said, no, we've already fixed this, we've already done this, we have jurisdiction up to 21. I started to research that, right, and to figure out how have other states done this? What do their laws look like? What do their statutes look like that give jurisdiction up to the age of 21, and start to research those laws and think about, could we follow those states? And I reached out to some of the amazing advocates in other states that had been part of changing their state law, and asked them about their process, right? How did you get started? Who were your partners? What opposition did you face? How did you get this through, right? How did you decide on this part of the language in your legislation, for example? And really learned a lot from those folks who had really paved the way. And then, I'm an immigration attorney. We do a little bit of state court work, really like exactly what SILA tells you not to do, right, is to go into state court and be an immigration attorney, you know, moonlighting in state court. I have not learned to be a family law attorney and a state court attorney. So in doing this, I had to really learn a lot about what our Colorado laws are for custody and guardianship. I dabbled in it a tiny bit, right, just for the purpose of getting predicate orders, but I didn't really understand the larger statutory scheme of custody, or the larger statutory scheme of guardianship. And I also, as well as dependency and neglect, are sort of child welfare laws. I really studied what those are and tried to sort of become better versed in those. And then also reached out to experts in those areas, right? Some of our family law attorneys that we partner with for the purpose of SIJS orders, but really that is their practice, right? That they are experts in family law. We talked a lot with what are in our state called guardians ad litem that represent youth in dependency and neglect proceedings, right? Talking to them about what the process is like, what the statute is, but also what the process is like for dependency and neglect, for custody, for guardianship. And then really partnered with a few of those folks to have them help with this legislation, to support it, but also to help draft it, and to make sure that what we were doing, with a narrow focus of helping immigrant youth obtain SIJ predicate orders, wasn't sort of messing with the larger statutory scheme, or wasn't going to create opposition from folks who practice in that area day in and day out, right? So one example was, we first started out with language that just changed the definition of minor and changed the definition of child to under 21 and unmarried. That was our first idea, right? Just change the whole statute. Well, by talking to family law attorneys and our family law bar, we realized we were going to piss off a lot of people if we did that, because, for example, child support only goes up to 18, right? There were all kinds of sort of unintended effects that we were going to be putting into place if we changed it across the board. But then we were able to get their support if we narrowed it and said, for this subset of kids, right, if you are residing with and dependent on a caregiver and you're seeking SIJS findings, then this broader definition of minor or child applies to you. So our law is very specific for youth seeking SIJS, because we didn't want to mess with the broader custody law or guardianship law or dependency and neglect law in our state. And that's the way that we were able to avoid opposition from a lot of those folks and actually get their support. We partnered, I think you could do it with any organization in your state that has a policy department, right, or has policy experts. They don't necessarily need to be immigration policy experts, but somebody who's been through this process a bunch of passing bills and knowing how to get it done. For us, we had a good relationship with our Colorado chapter of the ACLU and their policy department. We told them about what the problem was and what we wanted to fix, and they really partnered with us and helped lead us through the process. They are not experts in immigration law or in SIJS or even in custody or guardianship or dependency and neglect law, but they are experts in policy and legislation and how to get bills passed, right? And so we really relied on their expertise and their partnership in order to get this done. They also already had very deep relationships with wonderful legislators who really care about these issues and who really care about the immigrant community, and were able to put us in touch with those legislators. We were able to sort of make our pitch of, these kids are being left out. The federal law was meant to protect them up to the age of 21, but Colorado law doesn't match and is locking out our older youth from this protection. They really cared about that and cared about these older youth, and got on board and agreed to sponsor. But I could not have done that. I wouldn't have even known where to start, who to reach out to, and so it was really key to partner with an organization that had policy folks that had those relationships with legislators and could introduce us and help us develop those relationships. And then the rest of my role in that was really to help draft the legislation. I will say one thing that I learned doing this first bill in 2019 was, at first I just sort of described what we wanted to the drafter, and then she drafted the bill, and myself and the others who I was partnering with that are experts in custody and guardianship were like, no, that's not what we need. We need to tweak it. We need to change it. What we actually need is this. That doesn't work. And then I sort of learned, like, why didn't we just draft the language that we wanted rather than sort of being so deferential to the drafter? They can help you figure out where it goes in the statute, or to make sure it lines up, and coincides with other areas of the statute, that it's cited correctly, numbered correctly, all that kind of stuff, but they're not subject matter experts, right? That's you. You know the language. You, in partnership with family law attorneys and whatnot, know the language that you need in your statute to work for our kiddos. So that in this particular bill, it took a lot of going back and forth with the drafter to make sure that we got the language the way that we needed it. And then really, it became clear through this process that, like, everyone has their lane, right? Like, the folks at the ACLU were really good at policy and knowing the legislators and getting the sponsoring legislators' colleagues on board, right, and lobbying them for this important change in legislation. The legislators had their amazing role of getting it through, but really, like, you are the subject matter expertise, right? Expert. You need to provide that expertise both in drafting the language how you want it, as well as responding to opposition, responding to, for example, somebody saying from the family law bar, we are going to oppose this if you keep it as broad as it is. We will support you if you narrow it and say the definition of minor only applies to this group of folks, for example. You're the one who knows, is that going to be okay? Is that going to, work for what we need for SIJS predicate orders? And then this bill was quite contentious. We, I mentioned that we're a blue legislature, but we're also we're bluish purple, right? We also have it's quite mixed, and I have learned really anything immigrant related is going to get opposition from the Republicans in Colorado. That might not be true everywhere, but that is true here. So even though this was about children and about children who have been abused, neglected, and abandoned, because it was about immigrant children, we did get quite a bit of opposition, and we had to respond to that and also respond to hostile amendments that were proposed. For example, there was an amendment that was proposed to exclude youth from this state court process who had any kind of criminal or juvenile delinquency history. And we had to respond to that and be like, no, that has nothing to do with SIJS predicate orders. Children with delinquency or criminal issues might be abused, neglected, and abandoned and need a guardian as much as anybody else, right? And be able to respond to those amendments or those points of opposition and provide that expertise to make sure that the bill that ultimately passes is what you need to serve your clients the best. So that was kind of our process to get to House Bill 19-1042. This is a link in your materials, and I also, I think I meant to provide the actual statute, and I didn't, but it's okay. It's linkable, or literally you can Google Colorado House Bill 19-1042, and it'll come up for you the exact language of the statute. But what it does is it defines, it changes the definition of child and minor, which were defined in our custody and guardianship statutes as under 18 to under 21 and unmarried for kiddos seeking SIJS. Again, we had to narrow it. It allows orders to be entered up to 21 for youth that are residing with and dependent on a caregiver and seeking SIJS findings. And then I mentioned at the very beginning, you know, one of the problems is, or was, sometimes continues to be, that judges didn't understand their authority to enter SIJS findings, right? And up until then, there was no explicit authority in Colorado law to enter these findings. It was more implicit in their authority to enter findings about best interests of youth, right? Or to enter findings about custody or dependency. And so we were having to sort of convince them that it was in their, that it was in their inherent authority, and we didn't actually have explicit authority in Colorado law. So we took this opportunity to make it explicit. And in both the custody and guardianship and our juvenile code, which is like dependency and neglect, delinquency, adoption, all those kinds of proceedings, we listed out what SIJS findings are, right? That the court has the authority to declare the child dependent on the court or make a custodial placement, make the reunification finding, the best interest finding. And we also put in a really helpful word, shall, that the court shall enter SIJS findings when requested and supported by sufficient evidence. So that's been helpful when certain jurisdictions have wanted to push back on their authority to do it, to have explicit authority and to have almost like, an instructive in the statute that they shall enter the findings. That's been really helpful. Okay, looking at time. Okay, I think I'm about halfway through, which is good. Okay. The second problem that we've had, these are just two bills that we're highlighting. So a second problem that I was thinking would be most relevant to the folks on this call, for those of you that are serving youth who are in ORR custody, right, who are in shelters or detention centers or LTFCs in your state. For us, we had kids come into OR custody for the first time in Colorado in 2019, 2020. And we were screening youth all the time, right, and finding that they were SIJS eligible, but then they had no way to actually start the SIJS process in Colorado, right? They're in ORR custody. I couldn't go in and file a guardianship petition for them or a custody petition for them. There was no way to get them into state court, and this was particularly problematic for our youth who were staying detained long-term, right? We had a residential treatment center for really traumatized girls that were staying had very extended lengths of stay. They were all SIJS eligible, but we couldn't get into court to seek SIJS for them. We also had youth approaching age out, right, where we felt like if we don't get an order for them now before they age out, who knows if they're going to a place, to a jurisdiction where they would be able to get an order after they turn 18. So in situations like that, we were really desperate to be able to pursue SIJS relief for these kiddos. So really quickly, if we could launch The second poll, perfect, thank you. Do you have this problem in your state? Yep, we are also unable to get SIJS orders for kids in ORR custody in our state. Nope, we've already fixed this. We're able to get SIJS orders for kids in ORR custody in my state. It depends, maybe for some youth, maybe for LCFC youth, yes, but not youth in detention, or, you know, certain jurisdictions, yes, maybe others, no. And then I don't know, I don't work with youth in ORR custody, or I've never looked at whether or not there could be already a pathway for kids to get into state court who are in ORR custody. While people are filling out that poll, I just want to make sure that I have this right, that I have until 12:30. Is that right? Will somebody?
I'm double checking right now.
Thank
Let's see,
like another 30 minutes?
12:25?
12:25. Okay, 25
Yeah.
minutes. Thank you. That's helpful. I just want to
No
make sure I
problem.
didn't keep rambling on. Okay, so we're over 50%. Let's give it one more second here, but it looks like this is fascinating to me. I want to talk to all these 25% of people answering that you're able to get SIJS orders for kids in ORR custody. I wonder if you're all in the same states, or if there are more states than I am aware of where that's possible, but that is fantastic. When we were doing this bill in 2021, 2022, there, I believe, and maybe we were wrong, but I think that there were only 7 states where it was possible to get SIJS orders for detained kiddos. So I'm glad to see it looks like maybe there are more now. Okay, but it does look like at least maybe 16% or so of those who have participated. Do I hit share, or do you hit share, Serena? You got it. Okay, great. Thank you. Okay, so yeah, landed at about 16% that this is still a problem in some states. So hopefully relevant, at least for those folks, maybe for those that it depends, and for those who haven't checked into this yet. But again, so glad to hear that for 25%, this is already handled in your state, and I hope that it gets handled in all 50. So I will close it. And okay, great. Okay, so really similarly, right? First step was to look at those states that do allow detained SIJS. I have to give a huge shout out to a fellow that I had at the time, Eva Belakovic. This bill never would have happened without her. She did sort of a survey of 50 states to figure out where is detained SIJS possible, what statutes do they have, to kind of try to figure out how it's possible in those states. What we've found, at least in our research, and again, we're not experts in this in any way, and I think Acacia is actually trying to survey states to figure out how detained SIJS is or could be possible. So there'll be much more information on this, but at least from what we were able to find in 2021 when we were doing this research, is that the states that have detained SIJS possibility either had an institutional guardianship, like California, which we don't have in Colorado, and I won't go into, but there were several reasons why that wasn't the way that we wanted to go. But for those who didn't go the institutional guardianship route, but instead went more of sort of a dependency type proceeding route, or child welfare kind of filing route, it looked like those statutes, for the most part, already allowed the child or the child's representative or an interested person concerned about the welfare of a child, or just an individual, to petition the court to initiate that child welfare proceeding. At least according to our research, there were about 22 states that had statutes on the books that allowed the child or an interested person or somebody concerned about the welfare of a child to initiate child welfare proceedings. In Colorado, we learned we don't have that. Even though the statute is a little unclear, the case law makes very clear that only our Department of Human Services, only our child welfare agency, can petition the court to initiate a child welfare proceeding. So then we thought, okay, well, these are all dependent and neglected children under the definition of Colorado law, children that have been subjected to abuse and neglect, who don't have a safe caregiver. So let's just go to the Department of Human Services and tell them, hey, we have this small group of kids in detention in Colorado who are going to be here long term, right? Or who need to initiate this proceeding while they're still here in Colorado in ORR custody. Department, why don't you go ahead and petition the court to initiate a child welfare proceeding for them? And, you know, even in the beginning, we thought we would seek specific consent from ORR in order to have the child transferred from ORR custody to transfer them into foster care in Colorado. That didn't go well. That was not received well at all. Like I'm sure most state and county departments of human services and child welfare agencies, right, they're underfunded and overworked and already have, you know, a lot of kids that they're trying to serve and provide placements for. So the idea that they were going to go in and file for this group, we only had 50 beds in Colorado, so for some subset of those youth that we needed to start SIJS petitions for, was not going to happen. Another reason why it wasn't going to happen is again, right, we're not child welfare experts. We're not experts in the statutes of dependency and neglect, but what we learned as we researched it more, where was I? Okay, so as we researched what we were actually asking the department to do, the more and more we realized this isn't a good fit. Like this is apples and oranges, sort of what a traditional dependency and neglect legal proceeding is in Colorado. I like to think of as sort of A to Z, right? That all kinds of procedural steps and safeguards and mechanisms get kicked into place with the department filing a dependency and neglect. Parents are not only noticed, but they are appointed an attorney, and they are provided a treatment plan to try to do whatever steps are necessary in order to regain custody of their child or keep custody of their child. It can result in termination of parental rights. There's all these steps that happen that we're like, wait, we don't need any of those. We need the court to declare the child dependent or to make a custodial determination and to get SIJS findings, right? And so then what we turned to was modeling, at least in Colorado, off of what I call dependency and neglect light that is used for unaccompanied refugee minors, where the process is like A to C instead of A to Z, right? Where the department still files a petition in dependency and neglect for those kiddos, but because of a federal regulation that is applicable only to URMs, parents aren't noticed, and certainly none of the other things kick in, right? Where then the parents would be appointed counsel, and then it was possible to terminate parental rights. None of that happens in our URM dependency and neglect proceedings. So we were like, okay, how do we model that? How do we have a much shorter process that would only apply to these youth? And at first, we made the mistake of going into the broader dependency and neglect law because, again, I feel like so many of us are stuck in this mentality of, well, that's the law that's like written in stone on the books, and so that's what we're stuck with and have to mess with, right? It didn't occur to me that we could just create a whole new law. So we first went to the traditional dependency and neglect, and we're like, okay, there's steps A through Z. We'll go in there and on each one say, this step is not required for youth who are in ORR custody. Neither is this step, and this doesn't apply, right? And really like trying to carve out the small, you know, dependency and neglect light type proceeding that we wanted out of the larger dependency and neglect proceeding that exists in Colorado statute. And it was in a stakeholder meeting with the agency that oversees all the guardians ad litem that represent youth in these proceedings, where I credit her with us getting this done, because she said, why are you trying to mess with the existing statute? Why don't you just create a new statute that's only applicable to these youth in ORR custody? And it was like, oh, we could do that? Okay. So we did. We created this whole new dependency process that is not dependency and neglect. It is just dependency, which allows the child or the child's representative, okay, I'm going to go into it here in just a second when I go into what the statute does, I think. Can't actually see the bottom of what I did. Oh, what we did. Oh my gosh. Sorry if I'm making you all dizzy. I'm making myself dizzy. Okay. I can't see the bottom of my screen. There's something about partnering with folks. I think it was mostly partnering with the Guardians Ad Litem office, with our Child Protective Ombudsman that had already passed a law, that they had oversight over youth in ORR custody. So we partnered with them to make sure that our bills aligned and that youth getting these dependency orders would also get their oversight. And then we did not feel the need to really partner with ORR or our FFS, for example, or even our shelter on this, because we were not trying to change youth's custodial placement at this point. We had created a very mini process that gets the declaration of dependency and gets the SIJS findings that you need, but it did not contemplate changing the youth's custody, changing the custodial placement. Therefore, we were not going to have to ask for specific consent from ORR or change them out of the shelter placement. And so we let them know that once it passed, we let them know there were certain youth that we were able to do this for, and worked with them on it. But I wouldn't say that they were necessarily a big stakeholder in our process. So the solution that we came up with was House Bill 22-1319, which does create that narrow dependency process for youth in the custody of Office of Refugee Resettlement in Colorado. It allows the child or the child's representative to petition the county court where the youth is being detained or where the youth resides for a dependency declaration. We just need to show that the kid is actually in ORR custody. So usually we would file I'm forgetting what it's called, notice of placement or other records showing that they were in ORR custody in Colorado. We had to demonstrate that the child was dependent, which is a definition that we created in the law, which is that the child was subjected to abuse, neglect, and abandonment and under the jurisdiction of the state court. Then we would ask the court to declare the child dependent, and again, created a definition of what that means so that it wouldn't be just a like declaratory judgment. We felt like dependency had to mean something in the law, and so we created a definition of what does it mean to be declared dependent, because it is different than what it means in the larger dependency and neglect to be declared adjudicated a dependent and neglected child. That was different, right? So we were creating a new one and said, what does it mean to be declared dependent? That you were abused, neglected, or abandoned, and that you're under the jurisdiction of the court. And then we ask for SIJS findings, which are, it's pretty repetitive, right? Like what you need to be declared dependent on the court is pretty much what you need for SIJS findings too, at least in terms of the abuse, neglect, and abandonment findings. Our process, we wrote in that the court would typically have up to 35 days to schedule a hearing, but that if there were emergent circumstances such as the youth about to turn 18 or other emergent circumstances, that we could ask for a forthwith hearing and be scheduled within 7 days. The way that it turned out for the youth that we applied for, almost all of them, we went through that expedited process and were able to get SIJS orders within a week of filing. The judges were really receptive, and our ORR shelters closed down in Colorado in April of 2023, so we only had a little bit less than a year with this law to actually apply it. But I think we were able to help somewhere around 24 youth who all of their SIJS orders or all their SIJS petitions have been approved with these orders coming out of this dependency. law, which has been really exciting. And then we are about to get our first LTFC placements later this year, and we're hopeful that we can use this process for them as well, since those youth will also be in OR custody in Colorado. And then just really quickly, what we are doing good on time. So I won't go as quickly, but I'll just spend a couple minutes just briefly touching on some other sort of problems that we encountered with our clients, and then the legislative solutions that we were able to come up with. One was for U visa certifications. For those who aren't familiar, right, you need to go to law enforcement or the agency that investigated or prosecuted a crime in the U.S. to ask for a certification, for a signature saying, yes, this person was a victim of a crime, and they are being or are likely to be helpful in the investigation or prosecution of that crime. And what we had in Colorado, which I'm sure others, I don't have a poll for each of these, but I'm sure this is true in other states as well, where you have certain jurisdictions that are very immigrant friendly, that really want to help and will sign certifications routinely. Other jurisdictions, not so much, right? That also just really arbitrary discretionary policies developed by different police departments and DA's offices across the state, requiring a background check and only signing a certification if the victim herself didn't have any criminal history, or only if the case closed within the past 10 years or the past 5 years or the past year, or only if the case is still open, or only if the case is closed, or only if it's Tuesday, right? Like, there were just so many different discretionary policies, and we had like whole spreadsheets as U visa advocates across the state trying to track what police department had what policy, what DA's office would sign, what wouldn't. And it was really unfair, right, that you had survivors of the exact same crime who were just as harmed and just as helpful, and one would get a U visa certification on this side of the county line and one wouldn't on the other side of the county line, right? So it was really unfair. So we did exactly the same process, right? We looked and figured out that other states have already figured this out, in particular California. We followed their law really, really closely and got in touch with the advocates who were responsible for passing that legislation in California, and tried to model that here in Colorado, and ended up with House Bill 21-1060, which does create a statewide protocol that all law enforcement have to follow when they're asked to sign a U visa certification, including timelines, right? That they have to make a decision within a certain amount of time. This one I won't go into much at all. It's very specific to Colorado, but basically what happened is dependency and neglect I've referred to, right, as our general child welfare proceeding. They kind of divided that up to be dependency and neglect up to age 18, and then this for older foster youth. It's a new program called Foster Youth in Transition, but when they created it, there was no way out of that proceeding to get a dependency declaration or a custodial placement, much less anything in their law about being able to enter SIJS findings. So we worked with the folks who had passed that foster youth and transition law and said, hey, we're leaving out now, kids were able to do all of this when it was dependency and neglect up to 21. Now you've carved out this new process, which is great for a lot of reasons for our older foster youth, but we've now made it so that kids can't get SIJS predicate orders out of that proceeding. That's problematic. So we worked with them to amend their bill so that now we're able to get a declaration of dependency and SIJS findings for those older foster youth. One last one that I'll mention, which I hope is relevant for some of you. I wish I had a poll to figure out, but we've found that we don't have a clear, explicit statute in Colorado that says that parental death qualifies as abandonment. And as you all know, right, USGIS really wants to see that the state court is making the finding that the parent's death is abandonment, right? Not is a similar basis to abandonment, but really that the parental death is abandonment under state law. We had some good case law, but that wasn't working in a certain jurisdiction where we happen to have a lot of orphan youth and a lot of youth that needed this finding based on parental death. And so we were able to amend that statute this past legislative session to make it very clear and explicit in our SIJS statutes throughout custody, guardianship, dependency and neglect, all of them, that abandonment includes, but is not limited to, the death of one or both parents. So we are hopeful that that will fix the issue in that jurisdiction, and then also help USCIS see that there is clear statutory authority in Colorado that judges are using to make the determination that kids have been abandoned through parental death. The very last thing I'll say, and then I'll open it for questions, is it's been really probably the favorite part of my job, even though it's not even really part of my job, to do this legislation. You know, I love working directly with clients, but to be able to make changes that impact a much larger group of clients at once has been really, really gratifying. I've learned so much. It's really, really exciting. And then something that we started to do more recently is, you know, these are the bills that we have really led on the children's team anyway. And then we have also started to sort of participate in coalitions of other organizations across the state to help them lead legislation, to help, you know, lend our voice and our testimony in support of positive legislation, as well as to help kill negative anti-immigrant legislation. So anyway, it's been really fun. I will open it for questions now. Thank you so much.
Thank you so much, Ashley. And I can help facilitate the questions. There are a couple in the chat that I can just read out to start with. And if you do have more questions, we have 7 minutes, so feel free to share them and add them to the chat. Have you run into any problems with I-360 adjudication with state legislation that is carving out an exception for migrant youth that doesn't apply to non-migrant or non-SIJS seeking youth, such as the prohibition against filing for SIJS purposes only?
That's a great question, and something that we were also concerned about, especially when, for example, we had to say, oh, okay, now we're only changing the definition of child and minor for youth seeking SIJ orders and not more broadly. We were concerned about that too, but we have not had any problems with that with USCIS. And I will say, you know, the prohibition is against going in. I don't remember if it's that it's the sole purpose or the primary purpose, but there's always another purpose, right? Like there's always something else that a youth is getting out of the proceeding, whether it's, you know, a guardian who can sign them up for school, or, you know, have the right to make medical decisions, or whether it's a custodian who can apply for a passport for them without, you know, the other parent's signature, or there are always other valid reasons to get a state court order. And we don't actually even put a whole lot of that into our pleadings or anything, but I don't worry that the state court orders that we are getting are for the sole or even primary, maybe primary, but not the sole purpose of getting that underlying state court order. But no, luckily, knock on wood, we haven't had any problems with USCIS adjudication.
There's another quasi question, but just kind of clarifying that Jacob asked to confirm he heard correctly. Did you say that 2,000 children got SIJS findings in Colorado?
Oh gosh, I wish. No, 24. Sorry, we are small potatoes, not 2,000. I would need to look up to know exactly how many, but at least 20 we were able to do. But we only had the law on the books for less than a year, and then at least while we had youth that were detained in OR custody, and our max capacity at our facilities, which we never were at, was 50. So we felt pretty good about 20, but nowhere near 2,000.
Probably.
And hopefully we'll be able to do more with LTFC, but we'll see.
Any other questions coming in? I don't see any in the chat. Feel free to add them. We have a couple minutes left.
While people are thinking, I'll just put out there, this is my email address. You know, I mentioned that the first step in most of these bills was to reach out to folks in other states that had already done it. And I am more than happy to talk to folks. If you're considering doing this in your state, if you want to know more about what our process was, if I can send you, you know, our fact sheets or anything else that were helpful, I would love to pay it forward. There were really too many to name, and I don't want to take time or to miss anybody, but for every single bill, there were people in other states that helped me figure out how they did it, modeled their legislation, tried to, be prepared for the pitfalls that they had or the opposition that they encountered. There's no way we would have done any of these without advocates in other states who not only had already changed their laws, but who were willing to pick up the phone and talk to me and answer all my really basic elementary questions and spend time with me. Some even would come and testify remotely for our bills, which was really helpful. So if there's anything that I can do to help folks move it forward, any kind of legislation move forward in your states, please don't hesitate to reach out.
Thank you so much, Ashley.